once the site's up online, it's built, it's ready to go, who owns it?
This is where I have to put my make-believe lawyer hat on. The question is really about the word ownership. No web developer who understands at least minimal intellectual property laws will ever give full and complete ownership of a site. The problem with doing that, for instance, with our company, we use a lot of things that we call modules. So if you want a blog, we don't have to program it from scratch just because you want one. We have modules. Now they will be adapted, they will be changed, and they will all look differently and work differently. But the basic programming,
kind of what that's your product, basically.
Absolutely.
Modules. That's something you've made.
This is the worth of my company, is the intellectual property. And that consists of the programming applications that we have. If I built a site for you and I gave you ownership, ownership implies copyright also. So you would now be in a position where you could take the site that I built for you and build 10 more sites, or worse, become my competition.
Yeah.
If you don't do any of that, the fact is at that point you now own my company because I've given over the rights. So that can't happen with the word ownership. But the other extreme of that is a set of practices that we see over and over that we think are frankly underhanded. For instance, you decide that you want to leave the firm that you're with and you start speaking to me or another legitimate developer, and it turns out he looks up your domain name, he does what's called a whois search. You don't own it. You never did. The developer that built that site owns it and was essentially renting it to you. How much did you invest on brochures, letterhead, business cards that now are promoting your direct competition? Because the minute you cancel your contract with that firm, that's a good age domain. All they're going to do is go into the site, change the contact information, and hand it to the next highest bidder.
Yeah.
Bad practice. The other one is the site itself. Who owns the content? Often, as a way, going back to the how long does it take to build a site, many firms, their way of getting around that is having canned copy, content, text, so that the attorney doesn't have to do anything but write a check.
Yeah.
Which means that they can get the website up and running tomorrow.
But how good is that content?
Several problems with it. One, the quality of the content itself, but more importantly, they've probably used the same exact content 1,000 times.
Over and over again.
Which means Google probably banned it a long time ago. Which means you'll never get good rankings. Wow. And then last but not least, although it's probably buried in their contract somewhere, when you, for whatever reason, decide to move your site, none of that belongs to you, including the photos they used. In some cases, including the logo they designed for you. In an extreme case I remember coming across once, the attorney provided photos that now belong to the developer. So it is important that you investigate what the copyright provisions are when dealing with a developer.
Definitely.
Don't necessarily be in love with the word ownership, though, for the reasons I said earlier.
It's pretty key to scour the contract that you sign, obviously, and to cement these details out. That's your contractual relationship with the web development firm. So these are definitely some of the points that you have to keep in the back of your mind, you know, when you sign that contract.
In our case, once you've paid for the site, which is usually a one-time fee without ongoing stuff, the site is, in all intents and purposes, yours. If a year from now you decide you don't like my mustache, you can take your ball and go home. We'll give you your site on a disk, go to another hosting company, put it up.